Get off the monitor. Jefferson County Court at Law Number 2 is back in session. Let the record reflect that the jury panel is back in court. Let the record also reflect that the defendant, Mr. Brian Davis, is present. His attorney, Mr. Ryan Matuska, is also present. And let the record reflect that the state assistant district attorneys are present, Attorney Blake Ham and Assistant District Attorney Sonny Eckhart. State, are you ready?
State ready.
Defense, are you ready?
Yes, sir, Your Honor.
Okay. Ladies and gentlemen, at this time, I'll put you in the hands of our court coordinator, Miss Melanie Smith.
Hi, when I call your name, would you please have a seat in the jury box? David Moore. Charles Wilson. Randy Mott. Kelly Thibodeau. Anna Cormier. Karen Moore. Kay Boudreaux.
Okay. Ladies and gentlemen of the jury, earlier I mentioned to you that I had to administer to you 2 oaths. Earlier I administered to you the first oath. Now I must administer to you the second oath. Now, before we do that, State, you have any objections to the jury?
No objection.
Defense?
I do not, Your Honor.
Okay. Now, ladies and gentlemen of the jury, would you please raise your right hand? At the end of the oath, would you please say, "I do"? Now, do you and each of you do solemnly swear or affirm that in the case of the state of Texas versus Brian Davis, you will a true verdict render according to the law and the evidence, so help you God? Okay, you may put your hand down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I am the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I am the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her. And the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their case, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state have the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspapers or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The bailiff has handed you identification tags, identifying you as a juror. Please wear those tags at all times. Now, ladies and gentlemen of the panel, on behalf of Jefferson County Court at Law number 2 and its staff, I'd like to thank you for taking time out from your busy schedules to be here this afternoon. And also you showed up on Monday. Normally, when I excuse the panel, I usually shake their hands. But under our current situation, I'll give everyone an air handshake. And so, ladies and gentlemen of the panel, this will conclude your service here. Thanks again for being here. Now, you're gonna follow the bailiff. If you need any letters or anything from your job, for your job, or if you just need an excuse, he will direct you to the district clerk's office. So again, on behalf of staff here at County Court at Law Number 2 and the citizens of Jefferson County, thank you for being here this afternoon, and you are excused. And God bless you. Y'all have a blessed day. Now, ladies and gentlemen of the jury, the court has some preliminary matters that we need to take care of outside of the presence of the jury. You will be asked to come back on tomorrow. We have a hearing that will take place today into the evening. I don't know how long it's going to last, but you're going to be asked to come back tomorrow at 1 o'clock, and make sure that you have your badges. You're gonna have a seat outside because we may have some other matters going on the inside, okay? So at this time, ladies and gentlemen, you're in the hands of our bailiff, Mr. Porter. All right. Okay. Court is back in session. Cause number 319900. Case is filed, the state of Texas versus Brian Davis. We have present Mr. Brian Davis and his attorney, Mr. Ryan Matuska. We also have present State Assistant District Attorney, Mr. Blake Ham, and the other state sitting second chair, State Assistant District Attorney, Mr. Sonny Eckhorn. Mr. Bailiff, would you Okay. So, and ladies and gentlemen, let the record also reflect that the jury has been excused for the day. The jury is not in the courtroom.
If possible, I don't know if I would be going into any medical issues with my client in some of these arguments, but I would make a request to possibly have this not live stream.
Okay, and pursuant to Article 1.24 of the Texas Code of Criminal Procedure, the proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State, 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing rights or interests such as interest in security, preventing the disclosure of non-public information, or ensuring that a defendant receives a fair trial. The defense has requested that this proceeding be closed and not be live streamed. And the court finds that the parties seeking to close the hearing have advanced an overriding interest that is likely to be prejudicial to him. That is, it would ensure the closing is designed, is permitted so that the defendant will be ensured to have or receive a fair trial. The closure is no broader than necessary to protect that interest. And the trial court have considered reasonable alternatives to closing the proceeding. And the court makes the finding that the court's findings are adequate to support the closure. So at this time, this particular phase of the trial, which is a motion to suppress, filed by the defense, will be closed. State, do you have any objections?
No objections to